Well, thanks for staying with us. Now, the National Assembly is proposing a uniform 4-year renewable tenure for elected local government officials across the country. According to other proposals by the federal legislators in the Constitution Review, those contesting local government elections are expected to be not less than 25 years of age. Such contestants are required to hold a minimum of secondary school certificate or its equivalent and must be sponsored by a political party. A power to remove local government chairmen and vice chairmen is vested in councillors, thus stripping state governors of power to dissolve councils. The proposals are part of the broad recommendations by the Joint Constitution Review Committee of the Senate and House of Representatives adopted at the recent retreat in Lagos. Now, to help put this into perspective, we are joined by the Director, Abuja School of Social and Political Thought, Dr. Sam Amadi. Thank you so much, Dr. Amadi, for joining us right now. Does the National Assembly have the constitutional authority to impose a uniform 4-year tenure for local government officials, given Section 7 of the 1999 Constitution?
Well, the answer is yes, if they amend the Constitution. Of course, this is a constitutional review process. And so anything, if they amend the Constitution says what they say it says. So at this point, the Constitution says no, they cannot. But the Constitution says that the nature of the local government, establishment of local government is subject to is by law of the State House of Assembly. Now, if the National Assembly and of course the State of Assemblies succeed in altering the Constitution, then the Constitution provides otherwise, as long as they make the necessary adjustments to other sections, then it will hold. So first, the Constitution of Nigeria is subject to constitutional amendment. And if they go through that extensive process and succeed in altering it, it stands altered. So in that sense, they do have that power. The question then is that what they should be doing? Is it coherent? You know, the problem with constitutional amendments in Nigeria is that it suffers a lot of incoherence. They don't proceed from a theory of government. You see, those who did the 1979 and 1999 Constitution, in as much as we talk about some of the defects, they had a coherent political theory of the state they want to create. And so they recognize that local government will be established by the states assembly. The Constitution only proclaimed that there must be a local government. The Constitution classifies those local government and lists them in 776, 75, or 74 local governments. The Constitution says clearly what they are, who they are, where they're located. And the Constitution, because the Constitution knows that this local government will be funded from a physical framework that's national, they outline them. But they now say states should, create this local governments in line with the Constitution. And I think from an economic theory, political economy perspective, that's actually the right thing to do. Why? Because local governments should respond to local nuances. You see, the idea of what Chinese government practice, what they call directed improvisation, is that you leave the local to improvise, but you create a direction for them in that improvisation. And the Constitution has laid out duties, what they should do. There are constitutional obligations, fundamental human rights, basic constitutional protections, and standardizations that they can go. So I think I'm waiting for what theory justifies a uniform tenure for local government. I think that's our legislators should have in mind that local governments ought to vary in their nature, in their characteristics, because they respond to local reality. But the idea is that they want to federalize. There's a sense in which both the Supreme Court and the legislature are trying to federalize local government, which means the federal government creates some kind of structural straitjacket for local governments, and they fit into that straitjacket, without any deviation across the country. I don't know whether it makes sense from a political economic perspective. And as a constitutional lawyer too, I think, yes, they can do that. You can actually make the Constitution say anything it wants to say, as long as you follow the constitutionally outlined procedure to change the Constitution. That's the reality.
All right, now you've mentioned if the Constitution is amended, then they have the power to do that. But would this proposal require a full constitutional amendment? And what role must state houses of assembly play for it to become law?
Absolutely. Well, this is a report of the Constitutional Review Committee that's pending before the two houses. So after if they manage to pass this clause as it is, then this clause will be sent around the state local governments. Again, this is where the problem starts. So we've not had successful, if you like, trip around the states. Oftentimes the governors, we don't even have serious House of Assemblies across the country. By that I mean House of Assemblies where maybe because of the nature of the political parties, they are contested. The parties in the states are vibrant, and the legislators, go there to contest and struggle. And in which case, the normal parliamentary tradings happen, and you could defeat a proposal that the governor likes, or you could actually pass a law that the governor doesn't like. We've not had that happen. And so what we've had is that these constitutional deliberations die at this level of state assemblies, where the governors basically tell them what to approve or not to approve. So I won't be surprised that most of the governors in the south in Nigeria would instruct their state assemblies not to approve this kind of standardization, especially when it looks like it's evidently targeted at the state governments and the power of the state. So yes, likelihood of passing through state legislative muster is very low.
Now, could a uniform tenure infringe on the autonomy of states to legislate on, a local government administration?
Evidently, that's what it's aimed to. So if you standardize, you're taking out that constitutional provision that says the state assemblies shall make law for the establishment and administration of local governments. In this case, whenever you constitutionalize a principle or a policy, you have removed it from the normal play of politics. That's the idea here. So if you provide a constitutional provision that says it must be 4 years, then you have prohibited any state assembly from saying we want ours to be 2 years, 3 years. They must be followed. So essentially, the whole idea is to strip the states of the autonomy to determine the nature, the tenure, and the longevity otherwise of the state of the local governments. So directly, it's an assault on the state sovereignty. Again, it might be a good thing. It's constitutional. The Constitution allows the National Assembly to do what it's doing. The Constitution is written, but the National Assembly has the powers to rewrite those constitutions as long as they follow constitutional protection. And in good sense, the Constitution says, if you want to do these fundamental provisions, changing fundamental human rights, Section 7 about local government and all that, boundary adjustments, you don't just, sit in Abuja in the two chambers and agree. You still have to get to all across the country and get to thought of the state assemblies affirming, because this will be a fundamental revision of the political structure that the Constitution has authorized. So two questions. First is, does it make sense? Second question is, can you do it? Yes, you can do it. And doing it means you've decided that states should not be sovereign in the matter concerning the tenure of local government chairman. So it is an assault, it's a deprivation of state autonomy in that specific respect.
All right, thank you so much, Dr. Amadi, for having this conversation with us.
Thank you.